three new criminal laws, Bharatiya Nyaya Sahita, Bharatiya Nagrik Suraksha Sahita and the Bharatiya Sakshya Adhiniyam have come into effect across the country from today. July 1st has brought about these widespread changes to India's criminal justice system and ended colonial era laws. The new criminal laws will bring about a modern justice system, incorporating provisions such as zero FIR, online registration of police complaints, summons through electronic modes such as SMS, and mandatory videography of crime scenes for all heinous crimes. The three new criminal laws, Bharatiya Nyaya Sahita, Bharatiya Nagrik Suraksha Sahita and Bharatiya Sakshya Adhiniyam, are replacing the IPC, that is the Indian Penal Code of 1860, the Code of Criminal Procedure Act of 1898 and the Indian Evidence Act of 1872 respectively. Union Home Minister Amit Shah, who piloted the laws, said the new laws would give priority to providing justice, unlike the British-era laws that gave primacy to penal action. Let's take a look at all these changes. Let's describe to you what the old laws look like and what's changed, what's different, what's new in these legislations, which of course have now come into reality. So what's changed? Let's tell you first. So the old law was the Indian Penal Code of 1860. It's now become the Bharatiya Nyaya Sahita, or Second Sahita, as of course the technical term is. Also within this now, offences within India. So earlier, of course, the IPC section 2 would say rigorous imprisonment for a term. Now the section 13 under the Nyaya Sahita mandates rigorous imprisonment of a further period. Also, let's slow down a bit so we can describe for our viewers, of course, before changing the slide. Punishment for rape, as you can clearly see, of course, over here, under IPC 376 and IPC 3762 in the previous law, the age of consent was 15 years. Now the age of consent is 18 years. This, of course, under the section 764 of the new Nyaya Sahita. Let's tell you now about kidnapping or abducting. So under IPC section 366 earlier, it was mandated imprisonment of either description for a term, and now under section 87 of the Nyaya Sahita, it can extend to 7 years and a fine. All of this, of course, for kidnapping and abduction. Engaging a child in common offence. The punishment under IPC section 95 was imprisonment prescribed under not less than 7 years. Now under section 87 of the Nyaya Sahita, the imprisonment prescribed extends to 14 years. Also, of course, attempt to murder now. Let's talk about attempt to murder, where under IPC section 302, the imprisonment was for up to 10 years. Now under section 103 part 1 of the Nyaya Sahita, it's a life imprisonment and imprisonment for up to 10 years that's been mandated. If we talk about abetment of suicide, this of course fell under the jurisdiction of IPC section 306, where there was imprisonment of either description for a term. Now under the section 108 of the Nyaya Sahita, imprisonment extended to 10 years. Under the Terrorism Act, newly added, under IPC section 35, it was imprisonment or death sentence. Now under section 113 of the Nyaya Sahita, there's imprisonment or death sentence as well. So there's constants, of course, over there. We talk about assault or criminal force. This fell under IPC section 352. There was imprisonment for up to 10 years. Now under section 131 of the Nyaya Sahita, there is imprisonment of either description for a term. Under IPC section 363 for punishment for kidnapping, there was imprisonment of either description for a term. Now under section 1372 of the Nyaya Sahita, there is 7-year imprisonment or a fine. If we talk about trafficking of people, then under IPC 370, there was rigorous imprisonment for a term. Now the rigorous imprisonment can extend to 10 years under section 143 of the Nyaya Sahita. Now let's tell you about the Code of Criminal Procedure 1973. That's what it was called. It's been replaced by the Bharatiya Nagrik Suraksha Sahita 2023, as it was of course passed last year. So under this, the power to sell perishable property. Earlier, the CRPC section 459 mandated the rupees of consent was 500 rupees. Now under 505 of the Bharatiya Nagrik Suraksha Sahita, the rupees of consent is 1000 rupees. Meanwhile, payment to an innocent purchaser, the CRPC section 453 said out of such money a sum not exceeding the price paid can be taken. Bharatiya Nagrik Suraksha Sahita 499 mandates that money will be, of course, brought, and that, of course, is something which is changed in the new law. Meanwhile, in the order for custody, CRPC Section 366, proceedings shall be submitted to the High Court. Now, under 497 of the Bharatiya Nagrik Suraksha Sahita, the property of any kind or document which is produced before the court can be taken. The bond of accused and sureties, meanwhile, under CRPC Section 441, it could be imposed for the release of any person on bail. Now, under 485, it says person released on bail is to appear when called upon by the High Court. In the directions for grant of bail, earlier you could apply to the High Court or the Court of Session under CRPC Section 438. Now, under 482 of the Bharatiya Nagrik Suraksha Sahita, it deals with the saving of inherent power of the High Court. The power to commute sentence under CRPC Section 433 earlier was there were 4 clauses regarding commutation of a sentence. Now there are 5 new clauses which have been added regarding the commutation of a sentence under 474 of this new Sahita. Now, this is, of course, another newly added section in the mercy petition and death sentence matters. There was no law regarding mercy petition and death sentence in the CRPC Act. In 472 of the Bharatiya Nagrik Suraksha Sahita, release on bail for individuals or half of the maximum imprisonment there. Now, for those, of course, issuing a warrant under CRPC Section 425 earlier, any person within his local jurisdiction could issue this. Now, under 465, it can either be issued only by the judge or a magistrate. Abatement of appeals, earlier, of course, under Section 394 will abate on the death of accused. Now, they shall finally abate on the death of accused under 435. These, of course, remember, are all provisions also being done to declog the judiciary of so many pending matters. Now, under the treatment of victims, of course, under CRPC Section 357C, you could, of course, provide first aid or medical treatment free of cost. And now under 397, protection of children from sexual offences also, of course, comes into this ambit. Now, telling you a bit about the Indian Evidence Act, now 1872, which has been replaced by the Bharatiya Sakshya Adhiniyam 2023. Let's tell you about what all changes have happened here. So, under IEA Section 163, it's of course changed now to Bharatiya Sakshya Adhiniyam 166. This is for giving documents as evidence. So, now when a party calls for a document which he has given the other party notice to produce, of course, the other party is given a notice immediately to produce that evidence under that section. Judge's power to put questions under IE Section 165 shall not authorize any judge to compel any witness to answer any questions. Now, under 168, judge may order the production of any document or thing. Meanwhile, in the order of examinations, IEA Section 138 mandated cross-examination must relate to relevant facts. Now, under Section 143, the re-examination shall be directed to the explanation of the matters. Also, IEA Section 113B has been changed to Bharatiya Sakshya Adhiniyam 118. This presumes to, this is on presumption as to dowry death. The court shall presume that such person had caused the dowry death. Now, admissions in civil cases, what all has changed there? Well, let's tell you, IEA Section 23 has said that the court can infer that the parties agreed that evidence of it should not be given. Bharatiya Sakshya Adhiniyam 21 says proof of confessions by or behalf of people making confessions and against them. Also, IEA Section 25 is changed to Bharatiya Sakshya Adhiniyam 23 Part 1. Confessions to police officers are inadmissible against the accused in court is, of course, what is still mandated. Now, the opinion as to handwriting. Well, earlier it mandated that the court has to form an opinion as to the person by whom any document is written under IEA Section 47. Now, under Section 41, the court relies on experts' opinions on foreign law, science, handwriting, as well as identification. Now, if we talk about proof, when a testing witness denies execution, that is IEA Section 71 is changed to Bharatiya Sakshya Adhiniyam 70, where the witness denies or does not recollect the execution of the document. Also, with regards to certified copies of public documents, that is IS Section 76, which is changed now to the Bharatiya Sakshya Adhiniyam 75, official duty is authorized to deliver such copies. And under Section 93, which is changed to Bharatiya Sakshya Adhiniyam 97, which of course pertains to exclusion of evidence. It applies accurately to existing facts. Evidence may not be given of facts.